All right. Good morning, everyone. It is Tuesday, May 10th, and I want to welcome you back. It's been about a month, actually, since we've done our last session. It's been a while. Of course, I'm just going to quickly point out a couple of things that I always point out. First off, our forum is private, but our sessions are public, and thus anything you say on this session will be recorded. Secondly, I have finally done it right. I have muted all participants upon entry. If you are unmuted, please make sure to talk or anything else. Please make sure that you mute yourself again once you are back on. Third, and I would just mention this, we are now at 10,100 people in our group. So we have finally hit past the 10,000 mark. Thrilled about that. Thank you to all who make our group a vibrant and wonderful place. Part of the reason that we are a wonderful place, and this is going to lead directly into my intro, is because of the caliber of professional that actually chooses to attend. It is the case that I think most of us spend a lifetime assembling information such that we could talk knowledgeably on just one of the subjects that Matt Wilson chooses to talk to us about almost monthly. Really, his expertise is exceptional. As a personal plug, I use him as my lawyer. But in addition to everything else, Matt is really one of those lawyers who not only talks the talk and walks the walk, but actually has deep knowledge in his field well beyond what he talks to us about every day. And to that end is able to really draw on a variety of experience that colors and informs as much as it entertains while he speaks. Matt is today going to talk to us about an ever-present subject, but one that is growing in importance every single day, and that is mortgage enforcement, particularly for those of us who have been in this field for about 5 years or less. There was really no problem that the market itself couldn't solve. In a rising market, any problem you make, any bad decision, any mortgage that you take on can easily be solved by either refinancing or selling. But what happens if the product itself becomes less valuable over time, which happens sometimes in real estate? We don't remember it, but it does happen. Those falling markets are really where lawyers start taking on the role of mortgage enforcement. And mortgage enforcement is going to become a larger and more substantive play for everyone in this field. To that end, we have Matt Wilson here to talk to us about that today from the buyer's perspective and from the realtor's perspective. We are immensely grateful for Matt's invaluable expertise in that regard. And because you're not here to listen to me drone on, I'm going to turn it right over to him. Matt, thank you. Please, over to you.
Thanks, Mark. Appreciate it. I am going to be talking about mortgage enforcement today. This is, of course, a growing, it's a field that is always important, but, in times of downturn, it is going to be something you see more of. So I don't have a slideshow. I will be putting a document up later. But I thought, looking at this from the buyer's perspective, from the real estate agent perspective, I thought I would go through, just give a little bit of background first about, mortgage enforcement generally. It's not, an in-depth course on mortgage enforcement and what we do, but just so some basic understanding. And then I was going to go through some of the, it's a crazy things that lenders like. So when you are going and you're actually looking at helping a client perhaps buy a property that's being sold under power of sale, what are things that you might want to keep an eye out for, things that you want to do, how you want to be able to get engaged. And we're talking about power of sale because power of sale is by far the most common remedy used in mortgage default in Ontario, especially in the residential sphere. When you're into large commercial transactions, a lot of commercial mortgages, you might look into receiverships, you might look into other avenues. I have some clients I do mortgage enforcement work for who have lent in, for example, the agricultural space, in cannabis. You can imagine what's happening in that space over the last few years. You've seen it in the news. How you deal with mortgage enforcement if you're dealing with a cannabis legal grow operation is very different than if it's a subdivision home on a lot somewhere that they just happen to get behind in the mortgage. So power of sale is typically the most common. It's used in, I would say, 99.9% of at least residential mortgage enforcement. There are two other paths to go down. One is a judicial power of sale, which is exactly what it sounds like. It's power of sale under court supervision. Sometimes if it's really contentious, a lender might look at going down that avenue because it also provides them with some court protection. It's harder to argue improvident sale or the lender selling the property for undervalue if the court's already signed off on what the value they got for it was. But it takes more time because you're dealing with court. The other is foreclosure, and foreclosure is different than power of sale. So I'm sorry if I'm bursting people's bubbles here and creating this chaos. I also apologize, by the way, if everyone on this call already knew this, but it is different. There are some jurisdictions that really do favor foreclosure over power of sale. There are some other jurisdictions that favor judicial sale over the private power of sale powers that we have. Foreclosure, the big difference is in a foreclosure, the lender effectively takes title to the property. So they take the property in full satisfaction of the debt. And there the key is full satisfaction of the debt. If you take the property and the property, if its mortgage is underwater, so the property is valued at less than what is owing under the mortgage, there is no further recourse. The lender can't go and sue them for the balance. Conversely, if the property is worth more than the mortgage is, then there's no accounting to the borrower. So all that extra equity gets to be kept by the lender. But there is a process where if you get served with foreclosure, that the borrower can convert that as of right, can convert that into a judicial sale. And since lenders really don't like the judicial sale process, it does provide a little stop towards them thinking about foreclosure in lots of ways, because there's, if there's extra equity, there's every incentive for conversion by the borrower to judicial sale. And of course, if there's going to be a loss on the mortgage, then lenders typically like going by power of sale, because if there's a shortfall, then under a power of sale, they could still sue the borrower for the extra shortfall. So a little bit of background. Today we're talking about power of sale. We're going to go through some of the stuff on the power of sale. And again, as background, lenders throughout a sale process have an obligation to try to get as close to true market value as possible. They have an obligation, it's not a fiduciary obligation, they do have an obligation to not sell the property improvidently, meaning they can't sell it for undervalue. They can't also sell it for something that's not market. They can't sell it to themselves. They can't sell it to something that's directly related. There are limits on what a lender can do. So when they are doing it right, what they're doing is they're advertising the property. So they're going on MLS, they're looking at ways of creating visibility for the property. And they're also arranging for appraisals, typically at least 2 appraisals of the property. So that way they know what they should be able to get for it, but also they will know, if they are selling it ridiculously undervalue, right? It doesn't matter if that's what the market is currently bearing, right? At least they have some obligation, like I said, to try to get the best value for it. If they sell it, you get an appraisal, it says it's worth 600, you're selling it for 575, you're not going to have an issue because it's within the ballpark of what the appraisal is. So that's sort of the process they'll want to go through. The lender does not have an obligation to hold on to the property though until values go up. So if the market tanks and because of that, values on properties all go down, everything's appraising really low because of it, and they still sell to that low appraisal, even if everyone thinks the market's going to come back up in 2 or 3 months, the lender doesn't have the obligation to hold on to the property. Agents who are being retained by the lender, of course, will need to follow what the lender is saying, what the lender's obligations are, and make sure they follow specific instructions. And I will say a couple things to note. You cannot advertise the property as being sold under power of sale. Now, I know this talk's going to be primarily on the buyer side, but I think, because people might be looking at this from both sides, this needs to be noted. You're not advertising as being under power of sale. Of course, it's really easy for them to find out that it's being sold under power of sale. Not because anything's registered, which there's not, but because there's going to be schedules that are going to be mandatory that the lender's going to want attached to the agreement of purchase and sale. And as soon as you provide that schedule to the buyer's agent, they're going to know, right? But at least it gets people in the door at an idea of what the fair market value would be. And I will also say, if this doesn't happen to you and you're a listing agent, congrats. Most lenders who know what they're doing will want to have amendments done to the listing agreement, especially with regards to when commission is earned. Because if you look at the listing agreement, and I'm sure all of you know this, especially people who read the forum, commission is typically earned when that offer actually is entered into, not when the transaction closes. But because there are ways more ways that these transactions might not close, the lenders can't be on the hook, shouldn't be on the hook for paying the commission if the deal falls apart, because obviously the lender doesn't want to have their own money on the line. And it wouldn't necessarily be fair to the borrower to add that cost of commission to the mortgage, if it's not actually something that happened and went through the full process. It is something I see fairly often. So just be prepared if you're being retained by a lender. This is something that they might want to ask for. Now, sometimes it's negotiable. Sometimes you can work with ways around it. If you take anything away from this morning's conversation, it's if you have a client who is looking at buying a property that's being sold under power of sale, get a lawyer involved ASAP. Because what you're going to want to do at the very minimum is get some searches done, preliminary title search, pull up parcel register, look at the terms of the mortgage, look at what else is on title, look at what's out there, run a writ search before you actually get into putting in the offer. Because you want to know what you're actually going to be dealing with. And there's certain things that the lenders will typically try to carve out that you want to be on top of, including things like sometimes construction liens, work orders, tax arrears, things like that, which I'm going to get into. But I thought the best way to actually get into this, and what might be the most helpful for people, is I have a standard starting form lender's schedule that when I'm working with lenders, we send out as to get attached to agreements of purchase and sale. It is quite comprehensive. It is, every lender has their own versions of this, their own nuances of this. There's a lot of this information a lot of the things it covers off is going to be the same. It might be presented in different ways. But what I thought I would do is I would take people through my schedule as a way to help us orient the discussion around things that the lender is going to put in there that buyers need to be aware of and agents need to be aware of, so that you can ask the questions. And also, it's important for serving our clients properly, it's important that they know what they're getting themselves into, because there is risks involved in buying property under power of sale. They might get a good deal, but there's going to be risks involved. So I'm going to pull this up, and then we will use this as a way to take us through what we're looking at here. So I highlighted throughout, and hopefully this is coming through. If it's not, Mark, you can yell at me. But if you don't,
you're good. Everyone
okay,
can see it.
Perfect. So this is, like I said, my form of schedule. I'll sort of take you through what is important to look out for. Not all lenders use the same schedule. There's some stuff that others might have that I don't. There's some lenders that might not have everything that I do. Okay, so let's go. First, of course, is the acknowledgement that the seller is the lender. And for those who are preparing these agreements, it might be John or Jane Smith or both of them that own the property. But if the lender is Bank of Montreal and the Bank of Montreal selling the property, then the Bank of Montreal is the seller on the agreement of purchase and sale, because that's who's actually entering into it. They are saying that there is default under the terms of the mortgage, which entitles the seller to exercise power of sale, and the requirements of the Mortgages Act have been complied with. In the old days, the lenders used to have to do a statutory declaration that would set out, what they've done and how they've complied with the Mortgages Act, and that would get, filed with the registry paper, transfer document. Those are now not done. They typically will still provide some sort of statement. It might be unsworn. And then the tick boxes in TerraView that are ticked off that say the same thing. So the lawyers effectively make the statement on the mortgage itself. So what are those requirements? I mean, first, typically what happens is a demand is given, sometimes accompanied by notice under the Bankruptcy and Insolvency Act. The Bankruptcy and Insolvency Act notice is required to be given if there's a possibility that, first off, the borrower is insolvent. Second, that the borrower's asset, where they're insolvent with, in this case, the house, is all or substantially all of their assets. And that this has been used in some connection with the business of the debtor. And now, of course, residential properties are typically, residential properties, but a lot of lenders will give that notice anyways in case they bought the house with the intention of having a home-based business in it, and they don't want to get caught offside with the Bankruptcy and Insolvency Act. So that provides a minimum 10-day waiting period. And this all starts when the mortgage is at least 15 days in arrears or in default. And then they provide notice of sale, which is a statutory document, which gives notice to everybody who might have an interest in the property subsequent to the actual mortgage itself, anyone who has a right to redeem, so including the owners, spouses of owners, if there's family law right claims potentially, that after 35 days after that notice, the property can be sold. So there's another 35-day waiting period. And then the lender has the right to go and sell the property. Now, of course, if there's the owners living at the property, you're typically not wanting to sell it with the owner still there. That usually doesn't go over well. In which case, then the lenders will also go to court. They will get a writ of possession. Sometimes the borrowers will find ways to stretch all of that out. There are lots of ways to stretch that all out as an aside. Interest, of course, continues to accrue through all of this. So it's sometimes not in the best interest of the borrower to stretch it out, but some do. And then if you get that writ of possession, so that now can be a while, it could be months, depending on how long the delay is. Then that gets filed with the sheriff, and then the sheriff goes and evicts the owner, and then there's a vacant property that can be sold. So as even just on that basis, this can be a very long process from when it starts to when you actually see a property listed. But the basic legal requirements are that notice of sale, given at least 15 days after default, and then you wait for the 35 days after that, and then you have the right to sell the property as the lender. So you're saying, yes, we have the right to do that. The big thing with power of sale properties is they are always going to be sold on an as is, where is basis. Right? No representations, no warranties. In fact, in most cases, the lenders will even say, if there's any representation or warranty in the agreement of purchase and sale standard template form, and by the way, this schedule is a schedule that we use attached to an AREA agreement of purchase and sale. Some lenders might have their own version of an agreement of purchase and sale that's not based on the AREA form, but most will use the AREA form with a schedule. As is, where is, no representations, no warranties with regards to anything. Everything is carved out. We will not give you any coverage on work orders, anything registered. We're not going to do anything with unless it's going to get removed through the mortgage. We're not going to give you any coverage or any claims with regards to defects, encroachments, deficiency orders, development charges, sewer charges. We're not going to say anything we've given you is accurate. You can't rely on anything. So where this comes in is a lot of times, I mean, not always, but a lot of times when a borrower is in a situation where they cannot pay their mortgage, it may be as a result of, strictly a financial hardship. And then there might be tax arrears or other things like that to look at. But it also might be because of going over budget on work or other things on the property. You want to look, therefore, at least consider, if you look at the property and you're like, okay, is the property recently renovated, recently worked on, or, is it half constructed? Is it falling apart? Is it, an absolute fixer-upper / dive where the municipality might have come in and there might be property standards issues or something like that? If you want any comfort in any of that, do all those investigations before putting in an offer. Because if a work order, in a typical transaction, if a work order is discovered prior to closing, then that's something that has to be dealt with by the lawyers. In power of sale situations, typically those are carved out, so it becomes a buyer's problem. And this also includes environmental. So the lender is not going to want to take any liability or any responsibility for anything from an environmental point of view whatsoever. So they're going to want to look at that again if there's any potential environmental concerns. The last clause here on paragraph 3, this sort of reverses the standard presumption at law, which is as soon as the agreement goes firm, the buyer acquires a beneficial interest in the property. The seller doesn't want this because, again, there might be a right of redemption, and we'll talk about redemption in a second, that would therefore potentially nullify that equitable interest in the property that the buyer has, and we don't want to get into that debate over these beneficial interests. The lenders will typically also build in a significant number of rights to either terminate the agreement or to extend closing. Because if anything comes up that they have to deal with, they don't want to be in a position where they would be considered in default. So instead, they go through the process of giving them every single out humanly possible. So buyers need to look for this because if they're planning on moving in on the closing date, that might not actually be the closing date. Buyers are accepting title to the property, subject to everything on title. So again, this goes back to the title search originally. The seller is only required to give an actual discharge in relation to anything in priority to that seller. So if there's 3 mortgages, right, the second position mortgagee could sell the property. They'd still have to pay out the first mortgagee sort of in the usual way, you know, where you sell and then you have a payout statement and you direct funds on closing and you give undertakings, but that would all be in relation to the first mortgage. The lender who is selling the property will not provide a discharge statement or a discharge because if they discharge their mortgage at or before sale, they actually then have no more right to sell the property because they're selling it under the mortgage. That mortgage gets wiped out with the sale. Anything subordinate to that mortgage also can get wiped out with the sale. Anything that's not postponed. This can include notices of leases, commercial leases. Residential leases are dealt with entirely differently. This is dealt with, even options to purchase that could be registered. There's a fair number of things that can get, kicked out by the mortgage sale, but there's no obligation to provide any sort of statements for any of those, and they will not be provided. If anything is going with the property, fixtures, chattels, stuff that is there, the seller is not going to provide any representations or warranties with regards to them, including with regards to ownership. So this is where you might be, again, doing your search beforehand to see if there's any notice of security interests registered. The seller will typically want any of those notices of security interest to be assumed by the buyer, right? Typically, there's no chattels included because they don't know who own them, but there's also typically no obligation for the lender seller to remove anything from the property either. So you are getting what you see, and it could be an absolute disaster. And then we get into possession, vacant possession. Typically, lenders are going to try as many ways possible to carve out any obligation to provide vacant possession. They're going to get that writ of possession potentially against the current owner, but they are not going to want to deal with tenancies, especially with residential tenancies. Residential tenancies are protected even in a power of sale situation. The one difference between a power of sale and a regular sale is with regards to eviction for purchaser's own use. So as I'm sure most people know, if you are wanting to evict for purchaser's own use in a regular, not power of sale situation, the eviction can only happen after the end of the fixed term tenancy. So if it's a 12-month term and you're 3 months into it, well, you're not getting them out until after that 12-month period is done. That rule, that restriction doesn't apply under power of sale. So even if you're in the middle of a fixed term tenancy, you can still evict earlier than that for purchaser's own use. As we all know, the landlord tenant board is also incredibly backed up. I imagine that will continue for quite a while. A lot of times the lender will not want to deal with it whatsoever. And they will say, no, we are selling it to you subject to any tenants that are there. And then you, the new buyers, if you want to move in, you deal with it. There are typically no adjustments. Lenders like to, at least post-closing adjustments. Lenders like to close the books on these things. If there is a tax arrear situation, figure it out up front, and then it could be dealt with. Because most cases, if there's something that comes up after closing, the lender's going to say, not my problem. You know, if they're not paying the mortgage, are they paying their property taxes? Right? There might not be a property tax lien yet because those take 3 years, but there could be significant tax arrears. There are a lot of times when, I think it's personally sloppy practice, but there are a lot of times when buyers' lawyers do not order tax certificates. Even if they don't order tax certificates in a regular situation because they want to rely on title insurance, if there's any lawyers on this call right now, if there's a power of sale, always order your tax certificate, order it early, because you will want it dealt with on closing because it's not going to be dealt with after closing. And sometimes tax arrears can be significant, 20, 30, 40, $50,000. It then becomes the problem of the buyer, and also who knows how title insurance is going to deal with it because the agreement effectively says it's your problem. So you are aware of it. Sometimes title insurance will give a hard time on those adjustments. Same issues with hydro, fuel oil. If it's a fuel oil situation, I feel bad for everyone on fuel oil right now as an aside because of where the price of fuel prices are. But they're not going to fill the tank. They're not going to get a credit for it. It is what it is. In the event the seller is unable to complete the agreement, the seller has a sole discretion, has the right to terminate the agreement. Again, this is something that is very standard. And this ties in with the possibility of redemption. So redemption is the right of the owner or anyone else having an interest in the property to pay off this mortgage. You know, they can pay it off and have a discharge. They can pay it off and take an assignment of it as well. And that, of course, would stop the sale. Now, the right of redemption is extinguished at certain points. If you enter into a firm agreement of purchase and sale, arguably at that point, and there is case law on it, the right of redemption extinguishes at that point. Having a clause like this does not make it a conditional transaction, the courts have said. The courts have said you can include something like this, but still have it as a firm deal from a point of extinguishing the right of redemption. That being said, lenders at times will still allow redemption after the legal cutoff. Sometimes they'll allow the redemption right to the day of closing. And any buyer who's buying the property needs to be aware of this risk. Right? They need to be aware of the risk that someone's going to come in, pay off the mortgage right before closing, transaction's done, you know, that they're not getting the house. Of course, a court can also put an injunction in. They can also do other things. This gives the lender the right to back out and to say, no, we're not going to therefore finish the sale because we can't anymore, or because we don't want to put anything else into it. Some lenders will have different clauses in this that give the lenders the option of either terminating or extending. So again, it's up to that lender how they want to do it. And sometimes, and usually even if they extend, they give the ultimate right still to terminate at their sole discretion. Now, sole discretion does mean still within good faith. I mean, there's case law on that as well. But, you know, if the parties redeem the mortgage, yeah, there's really no argument around the seller then saying, well, I can't sell it to you. Right? It is what it is. The buyer agrees not to register anything on title. This goes back to the buyer not having an equitable interest in the property, also not wanting to tie up title to the property because of this redemption right. This includes things like cautions, certificate of pending litigation, and saying if any of these things are registered, then the buyer's in default. The buyer agrees to assume all rental and leased items. If there's any rental hot water tank, the buyer is agreeing to assume them. There might not be any contract or any documentation, but they agree to do it. There is no UFI warranty. It's being carved out. So even though that's standard, we're not going to give you one. Counterparts is just a clause in here that says we can all sign this separately. By the way, I do think counterparts is something that the real estate industry should look into more because it would allow people to sign their own versions of the agreement. Of course, it's messy if there's a whole bunch of amendments because then you have to reflect them on both, but something to look into. HST is an interesting one because the seller, who's the lender, might not have all the information it needs to determine if the transaction truly is exempt from HST. The seller lender does not want to take any liability or responsibility with regards to HST. So it doesn't mean they're going to charge it on closing, unless it's a clear situation where HST applies. But they're going to typically include language where the buyer is agreeing to indemnify the seller if there is any ultimate HST liability. So again, be careful of that. It is an ongoing obligation that is laid out here. There is no liability for non-residency under the Income Tax Act for a power of sale on the lender. This also includes, therefore, some risk on the purchaser. So for those who are unaware, under the Income Tax Act, if the vendor seller is a non-resident of Canada, there is potential tax liability both on the buyer and on the seller. It's on the buyer if the seller does not pay taxes to CRA. Because there's no obligation to provide a clearance certificate if you're selling under a power of sale, there therefore is also no right to or obligation with regards to a holdback. But there is still potential exposure to the tax liability on behalf of the buyer. CRA in these situations do typically go after the seller, but just remember there is additional risk on the buyer in the case of buying a property that is being sold by the seller, seller lender, but the owner is a non-resident. Typically, there is, again, no assignability. The seller wants to be in control. Only keys that are in the seller's possession will actually be provided, so there might not be keys. We're not going to give you any Planning Act statements in the transfer. The buyer satisfies themselves with regards to compliance with the Planning Act. Now, of course, the transaction, as a seller's lawyer, as a lender's lawyer, I'm also going to want to ensure that I'm transferring good property, but again, it's right there. We only give you a covenant that we have the right to convey the property. We're not giving you any other covenants with regards to this. We are requiring title insurance because we want to protect ourselves as the lender. So we want to say, buyer, you have to buy title insurance. It covers you, the buyer, but that way you have less opportunity to come back on us because we'll say, no, go to your title insurer. There may be different requisition dates. Typically, lenders like really long requisition dates on these because they want time to try to deal with stuff. And that's basically everything that they throw in there. It's effectively, in some ways, a kitchen sink. But if you look at it from the point of view of the lender, they're going to want to limit their liability to effectively nil. They don't really know anything about the property. They don't want to take any responsibilities, and they want to truly sell the property as is, where is. From a buyer, right, there's that risk. You know, what am I getting? Do I know, like, if I'm buying just this thing as a potential fixer-upper or to tear it down, or if it's a vacant lot, But, if it's a property, if it has tenants, if the owner, it might have difficulties, if the property is damaged, if it's half through construction, there's a lot more risk here on behalf of the buyer. And at the end of the day, right, the seller has the obligation to still try to get the best sale price possible. So it's balancing those realities. It is a way, typically buyers can try to get good deals on these. It's not like these typically are going for hundreds of thousands of dollars over asking. Sometimes they do. So it is different than regular market. But if you are acting on it as a real estate agent, if you're dealing with it as a mortgage agent, if you're dealing with it as a lawyer, do not assume that these transactions are the same as any other real estate transaction, because they are not. It requires a lot more due diligence, a lot more going into things up front, a lot more disclosures to the buyer. Be proactive, do the research, figure it out. And buyers can have a fantastic experience through this if done right. So that sort of is all I wanted to go through today. I am happy to answer questions. I am happy to go through whatever else anyone else wants to go through at this point.
I'm going to start by just apologizing. I really advertised this session incorrectly. Had I advertised this as your typical Schedule A in power of sale situations, you would have been flooded, because I think most agents really don't understand what's contained there. So Matt, thank you for that. That's very, very, very useful stuff.
Well, thankfully the video will be available.
Yes, they will, and I'm going to properly mark it up when we post. But we have quite a few people here, so if anyone has any questions, someone just wrote one. Does the lender need to take possession of the owner-occupied property prior to commencing a power of sale?
No, they don't. In fact, in most cases, they'll actually issue that notice of sale before they actually get into occupancy or possession. Sometimes they will never go into possession if they don't have to. They're going to want to go through that procedure. A lot of times, because of the additional court costs, because of the additional time that things get dragged out, there are a lot of times that the current owners will just be like, okay, fine, I'm going to leave. Here's the date I'm going to leave at. And then they go. You don't always have to go to court. People try to avoid court.
Next question is, could we get a copy of the schedule for our use?
If people want a copy of the schedule, you can email me, message me through the Facebook group. I'm not going to post it, but I will share it. Of course, the caveat with the presentation, of course, this is not legal advice. Use it as your own risk. The caveat with any precedent is the same, right? You want to review it, you want to know it, you want to change it to your situation. Use at your own risk. But yes, if someone wants a copy of it, contact me and I will help you out.
Matt, can I ask the question that many people are probably thinking and perhaps don't want to ask? We have a lot of agents that are on this session. A lot of people see power of sale as opportunities. And what a lot of people don't realize is that the opportunities are not necessarily on the buying side, especially if it goes to MLS, and all things being equal, it just goes for something close to what its normal price is. But what's interesting about power of sales from an agent's perspective is, of course, the idea that lawyers are finding out about them first. How does an agent make a connection with a lawyer, perhaps someone who functions in this space regularly, such that they can find out about listings, and establish connections and buttress their power of sale practice? How is that practically done? I'm asking just because I know that question is going to come up, and I'm going to give you the opportunity to respond to that.
Well, the first thing, right, is to find out who does a lot of work for lenders, right? To build the relationship with those lawyers. There are real estate lawyers who might do power of sale one-off, but typically not. Typically, these are, myself included, lawyers who do a lot of work for lenders, and therefore they might be people to connect with. But of course, we can't tell you anything unless the lender says that we can share the information. This is going out to the market typically anyways. If you want to potentially get your first foot in the door, lenders are usually fine with it. But again, going back to what I said earlier, lenders have an obligation to try to get that best value. My advice to lenders when I work with them is, even if you have someone, this has come up. I've had, the next door neighbor reach out and say, I want to buy the property beside me. To which, the response is, we're happy to let you know when this is coming. We're happy to look at whatever offer you have, but we're looking at, marketing this to the public still. Because someone might come in with a higher offer, so make sure you put in your best. More on the commercial side, though, I will also see many times when someone will come before listing with a really good offer that beats the appraisal, and then at that point, and it can happen on the residential side. We can get some opinions in place that say this is reflective of what we would get on the open market. And then some lenders are comfortable with proceeding on that basis anyways. So, but get to know your friendly neighborhood lending lawyer who might be able to help you out with some heads up.
Terrific. Thank you, Matt. Matt, we have two questions that are pretty similar to one another. One, I have a power of sale purchase at tax included in is how I've prepared it. While I got it back as a counter offer, it said in addition to. And then the second question, which is a corollary, is in which instance would a power of sale be subject to HST?
Okay, first off, they're going in addition to because the lender doesn't want to have any liability with regards to HST if it's applicable, right? So, if they sell it for 500 and HST is in addition to, right, then they're getting that full 500 if HST applies. But if HST doesn't apply. But if HST does apply and they're 500 all in, right, then they're actually getting less, which impacts also potentially from an appraisal point of view, because appraisals are typically done on a in addition to tax basis if applicable. Again, mostly those because the lender doesn't want to have any liability with regards to HST. And no, it's not always commercial property. There are times when residential property or what people think are residential property would be subject to HST. They're commonly not. But for example, if the owner of the property takes input tax credits with regards to the property, then that would take it out of the HST exemption. There's no way for the seller, who's the lender, or the buyer to know if the current owner took input tax credits, because no one's going to tell them that. CRA is not going to disclose it, and usually the owner is non-cooperative with stuff like that. That's just one example of when the previously used residential property exemption wouldn't be available.
All right, the next question here is, can two agents list the same property, one on behalf of the lender and the other on behalf of the owner? So can you act in multiple?
So they're not going to be acting together because they're selling them under different regimes, right? So the owner is selling it just in the standard process. The lender is selling it under power of sale. Where I see the sort of conflicting situation happen, first off, the lender shouldn't be interfering with the owner's own sale if the owner is starting their own sale before the lender starts their sale. So there is this obligation of law not to interfere. However, the caveat on that is, of course, they actually have to be doing something to forward that sale. So if the owner starts their own sale and nothing's happening, they say, for example, they have it listed at a ridiculously high price that's not in line with appraisals, and they're not getting any showings, and they're not willing to drop the price, then the right is still there for the lender to go and sell it. You might then have two different listings for the same property with two different agents. It becomes somewhat messy, but yes, it is possible, but they're not typically done together. I will say in most cases, as long as the lender has comfort that the owner is actually trying to sell the property, lenders are in the business of lending money, right? They're not in the business of selling property. They're in the business of lending money on property. So they'd almost rather it be sold by the owner and they get paid out in the usual way. As long as sometimes we'll put a forbearance agreement in place that sets certain milestones and obligations. and it lays it all out. But typically that's what happens.
Okay. Any other questions, guys? Please feel free to just shout out if you like at this point.
On that point, I've done quite a few powers of sale. This was back in the 90s. And I would always approach the mortgage company. Sorry, this was before the mortgage company actually listed it. I was approached by the owners that said that they were having financial problems. They were behind in their mortgage. They'd received legal documents from the mortgage company saying what they were planning on doing. And the best thing to do is pick up the phone and contact the mortgage company. They will work directly with agents. They will put a couple of restrictions on it that you're not allowed to accept any agreement unless it goes through them. But as Matt just said, they're in the business of lending money. They don't want to sell the house. They don't want to be involved in it. They don't want to have to pay the legal fees and everything. So they will work with a realtor when they're in a position to take the house. They just don't want to. So always pick up the phone to them, and they're happy to hear from us. They will even guarantee your commission.
Good to know.
And there is a comment in here asking about if I'm anticipating more power of sale action in the coming years. I do anticipate more, not necessarily because of rising interest rates. I mean, that will potentially have an impact on, people might be renewing into higher rates than having difficulty in actually then cash flowing the new mortgage. But I am anticipating more because of costs for everything are going up. People have less money at the end of the day. And then who knows what happens. I also suggest, there are ways also that people can be worked with before going and actually having the property sold, right? Like, is there a way also to, I know this might not help any of the real estate agents on the call, and I apologize for that. But, is there a way for the property to be refinanced? Is there a way for, even combined with a sale, if there really is an issue, is there a way for the property to be refinanced even on a shorter term basis to give the owner more time to actually sell the property or to bridge into what may be a better market, right? There are ways to work with homeowners to try to figure some of this stuff out.
All right. Last chance for any last questions, guys.
There's just, I'm going to provide some clarity here on this one, just one little thread here about a situation where there's the second mortgage is putting the borrower into power of sale. Do they or do they not pay out the other debts, i.e. the first mortgage? So anything with priority would be paid out on the sale. So if it's the second who's selling, right? So they would get all the money from the sale, but then they would have to pay out the first and get the first discharged in the way that a first would typically be discharged. So, the first gets their money before the second, even if the second is the one who's running the power of sale. And then what happens is house is sold, we paid off everything that has priority, we have a pot of money left. And then the lawyer will look at who then has claims after that, second lender in this case. Is there a third lender? If so, that second lender holding that pot of money will pay off the third lender before anything goes to the homeowner. Sometimes there's enough money to pay the third lender off in full and still give some money to the homeowner. Sometimes there's not enough to pay off the third lender in full, and then the third lender gets everything else that's available. They're now unsecured for the balance of their debt. Homeowner gets nothing. It really all depends on the situation, but you go down the list. If you're selling it as the second, you've already paid off the first on closing. The second then pays off themselves and their sale expenses, and there's a section in the Mortgages Act which says what you can pay off. By the way, for the actual sale costs are a first charge even before, like if the second mortgagee sells it. The real estate agents, the lawyers, we all get paid, by the way, from those proceeds of sale before anything goes to against the principal of the second mortgage. And then if there's anything behind, third mortgage, if there's a writ holder, anything like that, there's all accounting that's done. It's actually a fairly detailed process because this can all be challenged in court. So it's a very detailed accounting process that's done. Any money that's left over goes to the homeowner. Typically, we get them to sign acknowledgements and releases and all those other things at the end of the day.
Terrific. All right. Well, Matt, can't thank you enough. And I want to just give a shout out as well to Matt Gibson, who's done previous Power of Sale talks for us as well, and has been duly answering questions as well and helping us out in the background. So thank you to all guys. This is a critical or a critically important area that will be growing in importance over the course of months and years as we enter into decisively different market conditions. At that time, choosing professionals who understand what they are doing is the height of your own competence. And both Matts on this channel, but Matt Wilson particularly, who has devoted his time to us today, is one such professional. And it's suggested that you keep that in mind when you yourself are tackling these issues and have your own questions. So thank you very much, Matt. Thank you to everyone who's attended, and I intend, as I promised, to post this with the requisite discussion point as to what it is that we discussed today, which I thought was incredibly valuable for everyone who attended. Thank you again.
Thank you.